Tech giants may soon be held accountable for defamatory content posted on their platforms following the anti-trolling bill proposed by the Morrison government last year. The new Social Media Bill 2022 was announced in December and drafted in February. It is aimed to increase control against online abuse by asking social media companies to identify people behind anonymous accounts. Prime Minister Scott Morrison says he wants to close the gap between real life and discourse online.
But most importantly, making sure that the rules that exist in the real world must exist in the digital and online world.
The new established framework for end users' information discourse orders will allow victims to obtain information from social media companies such as country location, data, and contact details for alleged perpetrators to proceed with defamation cases. CEO of the Online Hate Prevention Institute, Dr. Andre Obler, says there needs to be a legal response, but other approaches could have been considered.
There needs to be a legal response. There's a gap in the law. Defamation is not always, the best way to deal with these things, but it is a legal approach that currently exists. If the government wants a legal approach, maybe a better approach would be to create another law that specifically deals with trolling, rather than trying to tweak things around defamation law.
E-Safety Commissioner Julie Inman-Grant also criticised that the new social media bill, she says the push to unmask vicious online trolls is at risk of creating confusion that could counterfeit its effectiveness in tracking online abuse. In a press release, Inman-Grant says the bill contained conflation, confusion, and the oversimplification of complex technical and legal challenges. The government online safety watchdog also argued that actual legalization deals with more defamation laws than online abuse, saying the defamation laws were developed for the print age, not the digital age, and cannot keep pace with the velocity and volume of the social media commentary. Without knowing the perpetrator's identity, the defamation path becomes ineffective, but Dr. Obler says a lot of the law also deals with shielding and protection for the social media users and companies if they take the step of disclosing the perpetrator's identity. He says that the Senate Standing Committee on Legal and Constitutional Affairs has recommended to change the social media bill.
One of the ideas in the bill is that a social media company should ask a person's permission before disclosing their identity. And if the person doesn't agree, then they can only disclose it based on a court order. On a similar basis, the bill says that the company should only take down the person's defamatory statements if the person that posted them agrees. And the committee turned around and said, but the companies can take down anything they like, which they do all the time. Why should we suddenly say they can't take down harmful statements unless the poster agrees? Right? This is giving the harm more protection rather than creating a solution. So the committee suggested that bit be amended.
Another issue that Dr. Obler highlights is the bill refers to Australian citizens and applies only to people who have permanent visas. If this was passed as the law, it would mean the bill would not protect people who are against trolling, like an international student living in Australia, who would not be able to use the law because they are explicitly excluded from it. The second major gap that Dr. Obler explains is the removal of the content mentioned in the bill.
If we look at the Online Safety Act, removal means that no person in Australia can see it. So this is actually removal for defamation is a much stronger standard, and it's saying it's got to be taken down completely. Whereas if it's cyberbullying material attacking a child or attacking an adult in Australia, the company could just block viewing it in Australia and leave it online.
Dr. Obler believes that rather than just handing over the people's identities whenever someone makes an allegation, there does need to be some primary steps to see if there's some legitimacy to it.
Maybe an agency like that should be playing a role to say, okay, let's do a preliminary assessment of this complaint. Let's look at the content. Let's decide if this is a legitimate case of trolling. Is the correct solution simply ordering that the material be removed? Which if it was just added into the E-Safety Act, there was a whole mechanism for removing content, and that could be the end of it.
Ahead of the elections, the Morrison government is expected to support the proposed social media bill. Alyssa Sablé reporting from News Aplenty.